Welcome to AQMD On The Air. I'm your host, Philip Crabb. Our guest today brings over 50 years of air pollution control experience to his position as chairman of AQMD's Hearing Board, a quasi-judicial panel authorized to provide temporary relief from AQMD regulations under certain circumstances. Ed Camarena, thank you for joining us.
You're very welcome.
Well, could you tell us about AQMD's Hearing Board, how it started, its program through the years, and its mission today?
First of all, I want to emphasize that the Hearing Board is a independent, quasi-judicial body. It's not responsible to the district. It's basically responsible to the public. It's set up by state law. Every air district in California has a hearing board, and we're appointed by the governing board, but after that, it's hands-off. Our purpose, our mission is to provide transparency in the enforcement of air pollution regulations that affect the local sources, mostly industrial and commercial sources. And the hearing boards have been around since, at least since the 60s that I know of, and quite possibly since the establishment of air pollution districts in California back in the late 40s. Yeah. So it's been a while. There's 5 members. There has to be at least one doctor, at least one engineer, at least one attorney on the board, and we sit sort of in bank. All 5 of us sit and hear the cases. We have the authority to issue variances, to issue orders of abatement, to hear appeals from actions of the executive officer, and to hear petitions from the executive officer to revoke an operating permit. The cases that we have most often are variances and orders for abatement. The variances are there to provide temporary relief to sources that find themselves out of compliance, and the situation might be one that is outside of their reasonable control. It provides them temporary relief from the enforcement of the regulations, temporary relief, protection from penalties. To get a variance, they have to demonstrate a number of things. The most important things are that it is beyond their reasonable control, that the requiring immediate compliance it would be an arbitrary taking of property or closing the business, that allowing them to operate a bit longer while they get their act in order will not have an impact on the community. So we have to balance the impact on the company versus the impact on the community. And that during the variance that they'll mitigate or reduce their emissions to the maximum extent feasible, like changing work hours or outsourcing some of their work. Abatement orders are a bit different. That's where a source is unable or unwilling to comply. In that case, the district petitions the hearing board for an order for abatement. And if issued, what it says is shut down the offending activity now, or take the following steps to get back into compliance as soon as possible. The difference between that and a variance is that there's no protection from penalties. So every day that, even under the order for abatement, as they're moving towards compliance, they're still subject to penalties. And that provides a tremendous incentive to get their act together, get back into compliance. Then we hear appeals from actions of the executive officer, where a company maybe was denied a permit or was issued a permit with conditions that they felt were unreasonable, or a company may be denied emission reduction credits, which have a tremendous value. And finally, and this is very, very rare, and that is if the executive officer would petition for a revocation of a permit for a source that just isn't complying. I should mention that our hearings are all open to the public. We issue notice to the public for each hearing, and the proceedings are very much like a court proceeding. Sworn testimony from the petitioner, sworn testimony from the district. Public is given an opportunity to speak, and the board deliberates right there in public. We discuss the case, the evidence we've heard, and make our decision. This way, all parties know and understand the reasons for the decision and what the decision is. We get a wide range of litigants before us, from multinational corporations that have extensive legal resources to represent themselves, and resources to hire consultants and experts to defend them, down to small mom-and-pop operations, dry cleaner, service station, auto body shop, who may not have the resources to hire an attorney, so they represent themselves. And they may not be versed in the proceedings before the hearing board, so we've prepared a video that kind of walks them through the process. They still come in kind of bewildered, maybe, and the prosecutor's office, attorney representing the executive officer, they'll help them by asking questions to elicit the testimony that we need to make our decision. And if they don't, then the hearing board does make sure we ask the questions to elicit that information and make the right decision. Sometimes we have to hire professional translators because some of these people are not fluent in English and are uncomfortable with the language, and so we provide that assistance.
The hearing board is also kind of a barometer for the economy, including economic activity, the state of manufacturing. As those things are reflected in current hearing board cases today, can you give us your impressions about that topic?
We handle about 200 cases a year. We're getting a few more cases where the operator may have cut back on the maintenance of their pollution control equipment, or maybe didn't have the resources to buy the equipment necessary to meet some new standard. There we have to make the same determination that we make on all variances. Is this beyond their reasonable control? So we have to look at their finances. What would be the impact on the neighboring community? Are there homes, schools, residences, hospitals close by? What can be done to bring the sources to compliance as soon as possible? What can be done to reduce emissions from the source during the period of the variance? And if we are able to make all of the findings, we will issue the variance. If not, it'll be denied, and they'll have to go a different route.
Well, AQMD has long strived to be sensitive to the business community and to provide services to help them comply with our rules and regulations. Could you suggest any ways that AQMD could improve these types of services?
Continuing the effort to get the word out, especially to small businesses, of pending regulations, of upcoming deadlines of compliance. The small business has just as many agencies looking over their shoulder as a large corporation. Their resources are a lot less. And so they may not have the time to keep up with OSHA and labor laws and air pollution laws and water pollution laws and health laws, etc. And so the district needs to continue its effort, and it's been a good effort, to get the word out through newsletters with their business associations, through direct mailings, etc. I sit on the Budget Advisory Committee, and that's one of the things I'm going to tell them. Don't cut back on this. Just keep up that effort. It's important.
Well, Ed Camarena, thank you for joining us today, and thank you for your commitment and your passion in helping to clean the air.
You're very welcome. Thank you for inviting me.
Well, that's our show. Thank you for watching AQMD On The Air. I'm Philip Crabb. Visit us at cleanairconnections.org to learn how you can help us clean the air that we breathe.
Let's work together.